The Canadian Transportation Agency has been pressuring passengers to stay silent about its rulings on their complaints. Now, this is after amendments to the Canada Transportation Act. Our guest says it tilts the playing field in favour of airlines over passengers. We are joined by Paul Daly, Chair in Administrative Law and Governance at the University of Ottawa. So this is a Canadian press story. It quotes the Transportation Agency as saying that rulings, quote, must not be published unless all parties agree to it. What do you think? I mean, you think this, so this means if I bring a complaint, I don't know what previous rulings have been, but the airlines know very well. They have files of these things. So you say it tilts the playing field.
Exactly. I'm a little bit surprised by what the agency said. They make out there as if they don't have a choice. But the way I read the law that was changed last year, they do have a choice. When either an airline or a passenger requests that the details of the decision remain confidential, the law says the agency may decide that the decision should be kept under lock and key. It's not as if they must. It doesn't say shall, it says may. So they have a choice to make. So I'm a little bit surprised at the way they put their response to this problem, which is obviously causing a lot of concern because, as you say, the airlines would seem to have an advantage. If you're off, Andy, and your flight is delayed or cancelled and you want to make a complaint against Air Canada or Porter or WestJet or whoever it is, they have, as you say, piles of past decisions that they can rely on. They know all the details. And poor Andy, with only the facts in his own case, is really at a disadvantage.
It kind of amazes me, this, because usually rulings by panels in this case, well, are they usually publicly available when you get a public ombudsman of a type ruling here?
Well, if you take the Canada Transportation Agency, for example, which, by the way, is a very serious and reputable regulator, not just of airlines, but of very complex industries like railroads, for example, railroad decisions are public. Now, sometimes there'll be sensitive commercial information in railroad proceedings about car loads and economic analysis and things that companies have an interest in keeping under lock and key. And there's a very rigorous process for requesting that parts of those decisions remain confidential. Mm-hmm. Presumptively, decisions are public. And really, anybody like the Transportation Agency, which is exercising very significant powers which can affect people's rights and obligations, really those decisions should be public. Those proceedings should be open to the public. That's the core of the open justice principle, which is an integral part of the Canadian legal system, and indeed is linked to the freedom of expression that we all enjoy as Canadians under the Charter of Rights and Freedoms. If we don't know what's going on, we can't express ourselves about it, can we?
So, I mean, on the surface, it looks as though the current system is slanted towards the airlines in the sense that there's a backlog of more than 70,000 passenger complaints. I mean, I don't know if I'd even bother filing a complaint if I faced a delay like that. I mean, is that a fair characterization?
There are administrative tribunals we should just say, they're court-like bodies, not judges. So you're not appearing before a judge when you're before the Canada Transportation Agency, or in this instance, you're before a complaints resolution officer, most of the time as a staff member of the agency, but they do things like courts, and they're supposed to do them in a speedier and more efficient and cost-effective way. The idea is that instead of asking the courts that are already overburdened to do this, we'll ask an agency, an administrative tribunal, to do it quicker. That's evidently not what's happening at the moment. There are models in Canada of administrative tribunals that deal with high volumes of claims. Immigration and Refugee Board is an example. They have quite successfully managed to trim down their backlogs over the years. So I know you're feeling discouraged at the moment, Andy, about your chances of bringing a complaint, but I'm sure the agency can look at best practices in other tribunals and get things moving quickly and speedily the way they should.
Can I just ask you about one other thing that's made my head spin a bit? And apparently, in some cases where passengers have won an award, the airlines have sued them, the passengers. And it baffles me that the legislation would allow for that.
I confess I'm not familiar with the details of that. It sounds pretty bad, though. I mean, this really is a system that should be set up for the benefit of consumers. I mean, you can tell from my accent that I've not spent all of my life in Canada, spent a lot of time living in the European Union. And one of the nice things about being an air passenger in the European Union is the rules are super clear. You're delayed for 2 hours. Here's what you're entitled to. 3 hours, here's what you're entitled to. 4 hours, here's what you're entitled to. The rules are clear and they're easy to enforce. And of course, they're rules that are designed to compensate passengers. So they're not in the interests of the airlines. But really, we don't want a system where there can be tit for tat airlines suing customers. Really, what we want is a system that allows passengers to get what they bargained for with the airlines. That's what that system should be achieving. And if it's not achieving that, then yeah, we'd have some serious questions to ask.